Hello everyone, my name is Aurangzeb, and in this important video today we shall be talking about the weaknesses of international law. International law is a weak law. Why and how? Let's discuss it below. That this is even admitted by modern school of jurisprudence. According to opinion, international law is a weak law because it is a law between and not above the states. The weakness of international law is the main reason due to which Austrian school of thought is not prepared to give it the status of law. Generally speaking, following are some of the weaknesses of international law. Point number 1, it lacks proper codification. Point number 2, it lacks obligatory judicial settlement. Point number 3, it lacks the centralized executive authority. Point number 4, its sanctional force weak less effectively. Point number 5, the International Law Court has no power to enforce its decision. Point number 6, it has no jurisdiction over domestic matters. Point number 7, which is very important, other general weaknesses include impression of legal norms, obsolescence of legal procedure due to slow change, absence of law for regulating some new phenomena such as subversion, hijacking, or other form of terrorism. Due to the above weakness, the states often violate international law. It must be admitted, however, that while violating international law, the states refrain from denying its existence. Instead, they find excuses of many kinds to their actions appear legal. The other topic about international law is origin and development of international law, how it developed and started, etc. The origin and evolution of international law has a long history behind it. Some rudimentary rules of mutual understanding existed in earlier human society. However, the definite formation of international law began with the Roman period when rules, principles, and regulation of relations among people were laid down. Though the Roman Empire collapsed, but the observance of these rules of conduct continued to be followed, and this provided the basis of modern international law. With the rise of nation states, the rules of international law further emerged and developed. The emerging states of Europe, Britain, Portugal, France, Spain, etc., evolved some rules regarding conduct of war, preservation of neutrality, and demarcation of their colonial sphere. These rules were written agreements and constituted first written rules of international law. The written material of international law was started to be complied between 14th and 16th centuries. Many writers wrote books on the subject, out of which was also the famous book on the law of war and peace, written by Hugo Grotius, who is considered as the father of this subject. In the 19th century, international law became more mature and its proper codification began. Certain institutions were set up for this purpose, with the result that its laws were codified and precise. In the late 19th and in the beginning of 20th century, the codification process was speeded up. The Hague Conferences of 1899 and 1907 were landmark in this regard. The first Hague Conference of 1899 produced two covenants mainly dealing with pacific settlement of international disputes and with respect to the law on war on land. The second conference of 1907 produced 13 conventions dealing mainly with maritime law. After the World War I, League of Nations was established in September 1924. It appointed a committee for codification of international law. However, it could do little in this regard. After World War II, the international law took a new turn as UNO Charter, United Nations Organization Charter, gave an ample scope for codification. In 1947, International Law Commission was set up. The work entrusted to the Commission is the promotion, progress, and the development of international law and its codification. The Commission not only codified the existing rules of international law but also helped it in its development by drafting a number of new conventions. Now let's discuss the subjects of international law. The subject of the law are those to whom rules of law are immediately addressed, that is to say, they are directly obliged by the rules of law. In other words, persons to whom law attribute rights and duties are subjects of law. There is controversy among scholars and writers as to whether a state is or individuals are the subject of international law. There are two theories in this connection. The theory given by orthodox positives claims that the states are the subject of international law. On the other hand, Kelson and other writers hold the theory that it is in the ultimate analysis individuals alone are the subject of international law. According to first theory, also called positive theory, only states are subject of international law, while the individuals are its object. To those scholars, only states can make war and peace, can be partner in treaty or convention, and can refer a dispute in international court. The theory further says that the individual person has no legal standing except those his own state, and that he does not enjoy locus standi in international law. To sum up the theory, state alone is the subject of international law. The positive theory about the subjects of international law is opposed by Kelson and other writers. They provide quite opposite theory. According to them, in the ultimate analysis, individuals alone are the subject of international law. They say that if international law regulates the conduct of states, it actually regulates the conduct of individuals. In the words of Stovall, fundamentally the law of nations is a law of individual enforced through agency of the government of communities into which mankind is apportioned. The theory further says that the individuals do enjoy benefits and burden under international law, and that international law does create certain responsibilities and obligations for the individuals. In the modern world, the theory given by Coulson and others that individual is the subject of international law has a great weight. With the advent of the 20th century, the orthodox theory became obsolete and a powerful movement began for international recognition of individuals as subjects of international law. Consequently, the subject monopoly of states disappeared in the post-war period as individual persons came to be regarded as the final end, a beneficiary and a potential subject of international law. To sum up this video, in my opinion, the subjects of the international law are not the individuals but the states, because the treaties between the states are enforced by the International Court of Justice, not the individual agreements. I will end up here, and to enjoy my new videos, kindly subscribe and like my video and keep watching my videos on the topic of laws. This channel is not only national but this is international channel which shall help everyone to understand the scope and purpose of law, either it is national or international law. See you in the next video. Take care. Love you.